We are nothing sacred. We are nothing sacred. We are nothing sacred.
With Maxwell Silverhammer.
We are nothing sacred. With cruise control. We are nothing sacred.
Oh, yes, bitches. Welcome to Nothing Sacred. I'm Maxwell Silverhammer. Cruise Control had a prior engagement tonight, so you're stuck with me. But we also got Patrick Clifford of Clifford Senior Law as my guest here. How you doing, Patrick?
I'm doing well.
Good deal. So you're a elder law attorney, is that correct?
That's correct. I'm actually a certified elder law attorney. That's something I accomplished earlier this year. I'm one of 6 in the state of Nevada. It means I've had a little more training, a little bit more background, covering a broader spectrum of elder law. And since I've been doing it for a while and took an exam, hopefully means I know what I'm talking about.
Good deal. So okay, let's go back. So have you always been in law, or has this been a new thing, or how to give us a little history?
I have been a practicing attorney for over 25 years. For nearly 18 of those, I was in California working as a civil litigator, which I didn't find particularly fulfilling, particularly as time went on. So back in 2017, Kathy and I moved out to Las Vegas. I'd been admitted here since 2013, but hadn't been using my license. Hung up my shingle, opened my shop, and have been practicing exclusively in elder law ever since.
Nice. And Kathy's your wife, just so we all know, right?
It's my wife, my office manager, my legalese translator. We are quite literally a mom and pop operation.
Nice. So what made you choose elder law over anything else, like entertainment law or anything like that?
Well, first of all, I want to tell you that I don't know a single attorney who's actually practicing in the area of law that I went to law school for. I was going to be an environmental attorney, but that didn't work out. But I tell you, after 18 years as a civil litigator, I was completely burned out. I was frankly ready to give up the practice of law and, looking into doing something else. It was just the grind and feeling like I was just part of someone else's bottom line and not making the kind of difference that I would wanted to make. Now, I first learned that there was such a thing as elder law when my parents were going through their own final illnesses. And I thought, this could be something worth looking into. And I did, and ended up taking a training class with an organization I'm still part of. In fact, I'm providing content for them now. And it's just been so wildly fulfilling, just being able to actually help real people with real problems, often in the most difficult times of their lives.
Now, civil litigation, just to back up a little bit, is that like, you go into a store and you fall and you say, oh man, I was hurt, because you didn't have a wet floor sign or something?
Yep, that's what we're talking about.
Oh,
that's one example. I was doing wage and hour class actions for a while. I was doing, complex litigation and products liability. There's a broad spectrum of topics that people will sue each other over. So, but yeah, and there's always, that's one of the things that gets old real fast is it's always adversarial. It's never, a situation. You're always trying to get something for your client at the expense of someone else. I don't have to do that anymore.
It's like these guys that advertise on TV, right? That if you've had this happen, there's some real wild cases now. Like if you were molested as a Boy Scout, crazy stuff like that. I couldn't imagine. I guess somebody's found some kind of loophole there, huh?
Well, they've actually, in those cases, extended the statute of limitations. In different states have different rules, including essentially doing away with them altogether, at least for a short time. But now it's a very extended statute of limitations for things like that as well, particularly for childhood abuse cases. And yes, there's, and I hate to say this, but the law is in many respects a business, and, people's cases, frankly, get bought and sold. I've got this case, that's going to be worth millions and millions of dollars. How would you like to represent this person? And on the one hand, you want to make sure that the person has the best representation that they can, but that's one of the disheartening things about civil litigation is when cases are treated as commodities. And again, feeling like you're part of someone else's bottom line.
Well, that's, because I had a situation years ago where I got hit by a car and I must have called 4 or 5 different attorneys. And the guy who hit me at the time, his insurance had lapsed. So nobody wanted to take that case. And I'm thinking, hey, wait, I was hurt, man. I mean, I had an injury. This is a clear-cut case so I learned real quick that, like you said, I mean, you're basically, if there's nothing in it for you, you're not going to bother with it.
Well, I got to tell you, I was in the same situation. About 8 years ago, I was hit in an intersection by an unlicensed, uninsured 17-year-old driver. And I got what I could out of my uninsured motorist policy, but that was pretty much it. So, this is my civil litigation tip of the day: up your uninsured motorist coverage.
Here's the thing. Is there a clause? Because it seems like the people who drive without insurance get into many accidents. And I'm thinking, if you're driving without insurance, then you should probably try to obey the rules of the road and be as careful as possible. But is there some weird clause in the law that says if you drive without insurance, we'll allow you to, but you have to get in a lot of accidents?
Well, no, you're not allowed to drive without insurance. You're not allowed to drive without a license. You drive without insurance and they suspend your license. That's not going to physically stop people from driving, unfortunately. And it can be a problem like, if you're in a situation like you and I were both in, where you have people who now have no disincentive to get behind the wheel and start driving because they're judgment proof. No one's going to take the case because there's no money to be recovered. And it's unfortunate for the rest of us. I mean, at some point, they become such a danger to the community that, yes, there can be criminal liability, but don't hold your breath.
Wow, that's amazing. Because then meanwhile, people like us get screwed, obviously. So, well, it is.
Yeah, as I said, up your uninsured motorist coverage.
Wow, man. Well, getting into the elder law thing now, because obviously this is the meat of why I wanted to get you on. We had somebody on about a year ago who was a journalist with a paper for seniors out here. And he was talking about this guardianship fraud thing. And at one of the meetings that you and I go to, you spoke on it a little bit, but you said recently they've changed the laws now with that.
Yeah, and this has been a reform effort that's been going on since 2015. As many of your listeners are probably aware of, there were some very, very bad things going on in guardianship, particularly in Nevada, largely because of a lack of oversight. And there were bad actors out there who were taking advantage of the system and the people who were in it. There were abuses by private professional guardians and with accomplices in the system. People were forced to move out of their homes. Their homes were sold. The guardians would charge excessive fees. And it did come to light eventually through good investigative reporting. And the response started with criminal investigations. Some people went to prison. The most well-known is April Parks, who was one of the private professional guardians, certainly probably the most infamous. And she was sentenced to 16 to 40 years in prison. The attorney she was working with was disbarred. Others saw the writing on the wall and got out of guardianship altogether. Now, that's not to say that everyone who got out of guardianship did it because they were doing wrong, because there were reforms that came later, changes in the law, and what had been a pretty straightforward file a petition, get it rubber stamped, and get guardianship over someone became a lot more difficult to do. Some people didn't want to put in the work anymore, but these protections were put in place to protect people who were being placed under guardianship.
Interesting. So how did they change this? Was there a lot of lobbying or how did the changes come about with these?
So it was primarily came about again. There was awareness that was raised through investigative reporting. But really, the changes came from the top down, from the Nevada Supreme Court. And the Nevada Supreme Court in 2015 started a guardianship commission to see what was wrong with the system and what needed to be changed. And that became permanent in 2017. There is a standing guardianship commission now. And so they looked at the problem and they saw where the pain points were, and they put in place a new set of procedures that needed to be followed. A lot of reforms, changes in the law that came from the legislature. That was the lobbying part. And it has been made a real positive effect. I mean, things that I have to say, the things that happened, in 2015 prior to that never should have happened. Because the system was quite literally broken. You could get guardianship over someone without ever giving that person notice. So they'd show up at your door and say, hey, I'm your guardianship. You need to move out of the house. And the police are here with me. Here's a piece of paper from the court. Let's go.
Man.
So the changes, a lot of changes that have happened. One of the biggest is that anyone who has a guardianship petition filed, so someone can get guardianship over them. The nomenclature has changed too. They used to be called wards, now they're protected persons. But the proposed protected person will be appointed an attorney at no cost. It is a court-appointed attorney, and here in Clark County is usually from the Legal Aid Center of Southern Nevada. And that has made a huge difference because everyone has an advocate. And their model is they push for what the person wants. The judge gets to decide what's in the person's best interest. Not always the same thing, but it has made a huge difference. I have represented people under guardianship, people who were seeking to get guardianship over family members. I've represented people trying to remove guardians. All of these things, I have quite the perspective of all this. I've done it from a number of different angles. So I understand how it works. It's still not a perfect system, partially because it can get very, very expensive, particularly if someone who you might even need a guardian doesn't feel that they do. And so this is going to turn into a long drawn out court process. And there is a provision that says that, if the person needs guardianship, the court can order that the attorney's fees be paid out of that person's estate, but that assumes the person has an estate. And also you have to make that request with the very first petition you file in guardianship court. And a lot of people don't realize how difficult it is. They just want to get guardianship over mom because, mom can no longer take care of herself. And they start it on their own, and then they find out it's much, much more complex. And then they want to hire an attorney and someone like me, and I have to say, well, mom's not going to be paying for this. You are. Because if you don't put that in your initial filing, you're not going to get paid out of mom's estate. So like I said, that can be very, very expensive, particularly if mom doesn't think she needs a guardian or doesn't want a guardian or wants someone else to be her guardian. You end up going through all the way through to an evidentiary hearing where the judge is going to make a decision as to whether this person needs a guardian and who that should be.
That's the next question. At what point, because obviously that could be relative. Like somebody could look at me as a blind person and go, oh, he needs a guardian. How do you prove that, yes, this person does or does not need a guardian? What are the steps for that?
So the first step is filing a petition saying this person needs a guardian. And the baseline is, does this person have the capacity to make their own decisions? And if the answer is yes, then there shouldn't be a guardian appointed. Back in the day, there was a much more sweeping view of, well, this person's impaired, let's ship them off somewhere, put them under guardianship and be done with it. And again, that is not the case anymore. And with the petition, there needs to be a report that accompanies the petition filed usually by a doctor, but it can also be a social worker or a government worker like a police officer. When they get a call about someone and they go and do a wellness check and say, this person can no longer take care of themselves. There's actually a little bit of wiggle room there. Says kind of a catch-all, and says any other person who or report that the court finds persuasive. So just because you don't have a doctor's report, and maybe you're not going to get one, mom doesn't want to go to the doctor, mom hasn't been to the doctor in 40 years, if you filed a report saying, mom is giving all her money away to Nigerian princes, and mom's not paying the bills, and mom's going to lose her house, and mom can no longer make decisions, you can see from her decision-making process, then that could be enough.
So you got to provide some kind of proof.
Absolutely. And there is a legal standard, and that is capacity. Does this person have the requisite capacity to take care of themselves?
Right.
And that's a complex issue. It's one thing to be able to express your desires, but it's another thing to be able to carry that through. And of course, it's not always that clear. Someone could say, I want to go to Hawaii. Okay, great. We'd like to help you. So how are you going to get to Hawaii? Well, I'm going to go out here in front of the street and I'm going to wait for the train to come and take me. That person obviously does not have the capacity to follow through and make these desires a reality.
Okay. So that's because what sparked my interest in this is, again, using myself as an example, because I could see someone actually going, well, wait, he's blind, he lives by himself, because this obviously isn't just for seniors. It could be any age group,
Sure.
where somebody has a disability. And have you run across something like that where somebody, say, is in their 20s or 30s and probably could live alone, but obviously somebody thinks, well, they need a guardian. Could they live alone?
Well, first, I want to take a step back and say, yes, it can be any age. And there's a different set of rules, same type of structure, but a different set of rules for guardianship over minors versus guardianship over adults. And I do not handle minor guardianship cases as an elder law attorney, but that's not really the defining factor. There's a whole different set of considerations in there, including parental rights and, child protective services get involved, the whole foster care system, for example.
Right. Well, I'm just saying somebody in their 20. Oh, I'm sorry. But somebody in their, like,
no,
say,
and
go ahead.
Yes, we have seen that. I have had clients in their 30s and 40s. Unfortunately, the one in his 30s very clearly was not going to be able to take care of himself. He had actually been hit by a car, had suffered severe brain damage, and lived out what was left of his life essentially in a skilled nursing home. He never did recover. But this was one of those situations, he could not tell me what his desires were. So in that case, it was clear that he needed a guardian. But it was also, my job in that case is I had to make sure that his rights were being protected and that the procedural steps were being followed. For example, a guardian cannot deny that person visitors, not without an order of the court. So, and this happens a lot, where we see different sides of the family have different views. I like to think I've seen every family dynamic, but tomorrow's another day. Right. But if you say, well, my sister's no good, she should not be visiting my dad. Well, the guardian doesn't get to make that decision unless you go to court and say that, my sister is a danger to my dad and she's threatened him before, that type of thing. So that's one of the issues with guardianship. By the way, I'm getting off a little bit of a tangent here.
No, it's good.
But one of the issues is, part of the problem with guardianship is that it is all overseen by the courts. And there's a lot, everything you want to do, you have to go to the court to ask if it's not within just the routine. But there is a protected person's bill of rights. People under guardianship still have rights. I've represented guardians of someone in his 40s who unfortunately had a brain injury for different reasons. Tends to believe he doesn't need a guardian, but he doesn't really have much of a memory. And so really beyond what's happened in the past few days, he doesn't remember. He doesn't know why, doesn't remember why he's living in a skilled nursing facility or what has happened before. And it's kind of sad. But yes, it's people with disabilities. Actually, I've got a story for you right now. I have a case going on right now. It's a guardianship that is being transferred from California, and we're waiting for that paperwork to be done. And when it comes to Nevada, what we are going to try to do is lift the guardianship. And this is one of the reforms that we're looking at and is so important, is that the court is going to be looking for least restrictive alternatives to guardianship. So if someone doesn't need a guardian, we would rather not have them. This person can live on his own, really doesn't need a guardian. So we're going to try to get the guardianship removed and put something in place, perhaps like a type of agreement. And I don't know why I'm completely spacing on the term right now. Supportive assistance agreement. Yeah. So essentially it is that this person will have a counsel who's going to help with the decision-making process. Supported decision-making, that's the term I was looking for, which is a wonderful, less restrictive alternatives in the proper setting. Now, this is one of these reforms that came along. I think some people kind of overestimated the impact it was going to have. It's not a magic bullet and certainly not appropriate for every situation. But because courts are looking for less restrictive alternatives, certainly, we are going to be trying to get people the most autonomy and independence as possible. And frankly, times have changed. As I was saying, there was a time that anyone with any type of disability, the thought was, well, we'll just ship them off somewhere and then we won't worry about them. Clearly, they can't take care of themselves.
Right.
But that is not the prevailing view anymore. There are certainly people who have those views. And that is why it is so important that if those people are in the system, in the court system under guardianship, that they do have an attorney appointed, an advocate to talk about what they want. And if this person says, I really don't want a guardian, I really don't think I need one, then that's up for the judge to decide. That's when you present the evidence. This afternoon, I was listening to a wonderful webcast with Jim Birchholt, who used to run the guardianship program for the Legal Aid Center. And he was talking about a client he had who was in fact elderly, living on her own, some cognitive issues, but she could take care of herself, and got her in front of the judge and went through, what do you do on a day-by-day basis? This is a day in my life. And these are the decisions I make. These are the things I do. As you can see, I can take care of myself.
So the person can actually, I don't know, what do you call that person who supposedly needs the guard? Obviously the guardian is the guardian, but is it the dependent? What do they call them?
Not too long ago, they were referred to as wards, and you hear wards of the state. And that was one of the changes. It's a change in nomenclature, but it really also is a change in perception. Now they are protected persons. Ward seems to be, has connotations of, someone who is dependent, who needs to be taken care of. Whereas by calling them protected persons or proposed protected persons, once the petition is filed and before the order is granted, it really changes the focus. These are people who need to be protected so they're not being taken advantage of. And that's part of the problem that we have seen is some people think the pendulum has swung too far, in that, we obviously don't want guardianships if we can avoid them, but sometimes they're necessary. And if someone who really needs a guardian doesn't have one, you're essentially just throwing them to the wolves.
Right.
It's one thing to say, there were guardians who were doing bad things and therefore, we should clean up the system. Absolutely. But to make a blanket statement that all guardians are evil is dangerous, because there's plenty of other bad people out there willing to take advantage of seniors and other vulnerable people. And At least you have the court supervision to make sure that doesn't happen.
Well, and it's all perception, as you were saying earlier, where, somebody might think as an outsider, well, there's no possible way they could live on their own. Look at the disability they have, but yet, like say they have cerebral palsy or something, but yet they do, perfectly fine. They're all cognitively there. They get their bills paid. They can get their house cleaned, so that kind of thing, obviously, is a factor too. But now it sounds like they can actually kind of represent themselves a bit.
They can, but again, they're going to have a court-appointed attorney. Always a good idea. But and if they want to hire their own attorney, they can as well. I really doubt that a court is going to allow a person to represent themselves and disregard their court-appointed attorney. But the court-appointed attorney, like I said, will advocate for what that person wants. And again, this is at no cost to the proposed protected person. So, but they will make their wishes known. And unless there is evidence to show that they actually need a guardian and that there are no less restrictive alternatives available, then there shouldn't be a guardian.
Yeah, that's good. Well, like the case we're talking,
not like there aren't abuses. There are not like there aren't abuses, and but that is frankly my job as an attorney to make sure that those don't happen. And frankly, the entire legal profession should be on that. Britney Spears is a famous example. She should never have been, in California, they call it a conservatorship, not guardianship. Never should have been under conservatorship. And it took years and years and years to undo that. Just recently, it came out that Michael Orr, the young man who was the football player depicted in The Blind Side, starring Sandra Bullock, but that was a real person. That was a real story. Found out that he wasn't actually adopted by this family. They imposed a conservatorship that gave them the power to basically veto any contracts he might enter into. So not just playing football, but endorsements and movie rights and so forth and so on. Shouldn't have happened. But maybe it would have happened if there had been a court-appointed attorney.
And I'm not familiar with the Britney Spears case. What happened there?
So what happened is, as you might recall, Britney had a period of her life where she was, I think it's fair to say, out of control and was making bad decisions. And her father stepped in and said, well, no. Obviously, she cannot take care of herself. I should be her conservator, and I should be the one making decisions for her. Now, mind you, this is someone who's making millions of dollars a year, who is doing shows around the world, has no cognitive impairments that we know of. And this is a very key factor. There's a difference between having the capacity to make a decision and the judgment to make a good decision. And that is something that comes up quite frequently. Just because someone isn't making good decisions doesn't mean they can't make decisions. And frankly, those people shouldn't be under guardianship unless you're in a situation where it's so bad that they're going to be a danger to themselves or others. And depending on the cause of that, there are other legal proceedings that can be taken. For example, Legal 2000, which is an involuntary psychiatric hold for someone with a mental illness, which, by the way, does not include dementia. But there's a difference between making bad decisions and not having the capacity to make decisions. And the hardest ones we see are the people who are, what do we say? They're voluntarily self-negligent. Destructive, maybe, or, it's just they don't want to do what would be in their best interest. The client whose father's wishes were, he said, I want to drink and gamble till I die of kidney failure. And that was what he wanted. It was his choice. And that is why guardianship is such a serious issue. Do we want to take away people's ability to make decisions? And my take, and the take on the law, is that you have to lack the ability to make that decisions. It's not just mom's making bad decisions. I get those calls all the time. We have to stop mom from doing this. And well, good luck with that. They come to, I want to get power of attorney over my mother. Well, because she's doing X, Y, and Z. Well, you really don't get power of attorney over someone. You just become their agent and you can act on their behalf. And you can't make them do what they don't want to do because it's written into the law that this person's wishes override yours. So, and I do want to just talk about powers of attorney right now, just real quick. As I said, there are the courts are always looking for less restrictive alternatives. And if a person can no longer make decisions for themselves, can no longer handle their money, they may need a guardian. But it's much better if they have executed power of attorney documents where they name the person they want to make decisions. They can't make them for themselves. There's healthcare powers of attorney. There's general financial powers of attorney. It's not just financial stuff. It's, if you need to call, the utility company to get the service turned back on, or someone's been in a car accident, you have to go to the tow yard and get the car. These are things people don't think of. And there's also trusts. So if you put your assets in a trust, the trustee is the one who is taking care of the money. So if someone has, a well-executed power of attorney for healthcare, for financial, and a trust, you go to court, say, well, we need to get guardianship over this person. The court's going to say, why? Because they have already decided who they want taking care of them. And if the agents under power of attorney are doing the jobs, there's no need for guardianship. And it's so much easier that way. There are things that an agent under power of attorney can do that someone under guardianship, that the guardian would need to get court approval to do. What if you needed to sell the person's house? What if you needed to take out a reverse mortgage, for example? Well, if you want to do that under guardianship, you go to court. You file that petition, their attorney weighs in, you spend several hours on this, and the cost goes up and up and up. If you have given someone you trust the authority to do that, they just present the power of attorney saying, look, here's where the person gave me the authority to do this. I'm putting the house in the trust. Okay, simple as that. No need to go to court. You need to get the judge to sign off. Much, much simpler, much easier. Of course, again, you should pick someone you trust and who is trustworthy to take on that job. By the way, another great thing about that, if you name someone as your agent under power of attorney, you can fire them. You can say, I'm revoking this power of attorney. You no longer have the authority to act on my behalf. So you can't fire your guardian. Only the court can do that. So you get a lot more control being proactive.
So while you're still cognizant and able, it's always best to get that power of attorney, where you fill that paperwork out and get that all handled before something happens.
Absolutely. And I have been in my own personal life in that situation where Kathy and I had to take care of a family member who lost the capacity to make decisions. And we didn't have to go through guardianship. We had all the authority that we needed just with those documents. And I tell you what, it was like having a golden ticket. You show up and say, we need to do this. We need to close this bank account, or we need to get, this car taken, change the insurance, all of this. Here is our authority to do so. No court order required.
So really, this is something people should be working on. I know when we go to these meetings, this is something that's hammered home all the time. Elect some, get somebody to be your power of attorney, get the do not resuscitate or whatever, whatever you're trying to get. So handle that early, don't wait until it's too late, as you'd say.
Well, as I like to say, there's preventative medicine. What I do is preventative law. Preventive medicine is designed to keep you out of the hospital and avoid any future medical problems. I want to keep people out of court and avoid any future legal problems. Good legal planning, if you have a good trust and these powers of attorney, you probably will never need guardianship. You will avoid probate after you pass away. Not that you care, but you don't want to leave your kids with that problem as well. And do this while you can still make those decisions. As people are fond of saying, don't worry if you don't have a plan, the government has one for you. you probably won't like the government's plan as much as the one that you're going to put in place for yourself.
Right, right. It's the people you want, like you said, find somebody that you trust, that you know is going to have your best interest. So
exactly.
Wow, it's amazing. Now, with all this stuff that was happening back in the day with the whole guardianship fraud and that type of thing, would that have been avoided if people got power of attorney back then?
Not necessarily. And that's one of the reforms that came up. You see, the law used to say that if a guardian is appointed and you have a power of attorney, that document is now void and the agent can't act on your behalf anymore. So if you had a situation where, you had a bad actor like April Parks going to court saying, well, I should have guardianship over Brett, and, she knocks on your door with the police and said, you have to move out, or you're going to go live in an assisted living and I'm taking over all your finances. You say, well, I have a power of attorney. Oh, no, sorry. That's no longer valid.
So they used to be able to override that back then, huh?
Definitely, yeah. And even now, if a guardian is appointed, the power of attorney is suspended for that time. But the whole purpose of having that is so you can go into court and say, look, there is a less restrictive alternative available here. I don't want a guardian. I don't need a guardian because I have already chosen who I want to make decisions for me. And this person is acting on my behalf and they're taking care of me.
Wow.
And nowadays, now that people actually have to get notice, go figure that someone is trying to get guardianship over them. That type of thing shouldn't be happening. So again, there were changes in the law, long overdue, that has made it harder for people to engage in fraud.
So how does someone get notice that, hey, somebody's trying to become your guardian?
They have to be served with that petition and a notice of hearing. This is true in pretty much any legal proceeding. So they actually have to have it hand delivered, has to be served on them by a process server. So, sometimes, and again, the attorney is going to reach out to them as well. Once this petition is filed, the court is going to appoint an attorney for this person who will be reaching out to them as well. If you do not serve them with the petition, then it's not valid. And in fact, you actually have to serve that petition on all the family members as well, within 2 degrees of consanguinity. That's, on the bloodline. Essentially, it's your kids, your grandkids, your parents, your grandparents, and your siblings. So those people have to get notice. So, if you're worried about the bad sibling trying to take control of mom or dad, then the others are going to have a chance to show up. Of course, it's often hard to tell who the bad sibling is, but that's that's a story for another day. But, I've had people say, I want to file for guardianship, and that's all well and good. Great, we'll do that. And here's the process. And these are the people you have to give notice to. It's like, oh, no, I don't want to give notice to my sister. Well, you have to. If you don't, and your sister finds out and objects, then they could undo the guardianship. So if anyone, and that's one of the key things also, is once people get that notice, they can show up at the hearing of that petition. And if there's no objection, and, and we've had situations like this, certainly, where someone is obviously in need of a guardian and there's no one who's opposing it, the court will, at that first hearing, just say, and they'll be talking to the attorney for the protected person and say, is there any objection? No. Well, then, okay, we'll go ahead and do this. If someone says there is an objection, what's going to happen is it's going to be set for a further hearing. Sometimes the court will appoint an investigator. That's another reform that came about after 2015. They've established a guardianship compliance office where they can go and subpoena bank records, health records. They will dig and find if there's going to be a problem. Sometimes they do a better job than others. I've had issues with some of the reports they've done, and actually had to go to court and say, look, they didn't do their job right. But in any event, there will be this fact-finding period. And it follows the same rules of civil procedure. You can do discovery, you can take depositions, you can subpoena records, you can, all of these things. So you ultimately have an evidentiary hearing where you get before the judge and say, these are the reasons why this person doesn't need a guardian, or why this person shouldn't be this person's guardian, for example. So this is where it gets complex and expensive as well.
Well, some of the terms you just used were sort of legal jargon. So maybe like, what did you say? Discovery? Is that one of them?
Yes. So, and that is something that you do in civil procedure. You can request documents from the other side. You can take depositions, which are, interviews under oath. They're like essentially trial testimony. You can answer written questions that they have to respond to in writing as well. Like I said, you can subpoena records, from bank records, health records, school records, even employment records. It's cumbersome. It's time consuming, but that is how we gather evidence for trial. You don't just show up and say, well, this is our side of the story.
Right.
Okay. So, if you can say, well, there's all kinds of bank fraud going on. Well, really, do you have the bank records? Well, no. So if it becomes, a he said, she said type of situation, and quite frankly, there's rules of civil procedure that says if you could have presented better evidence and you didn't, it's not going to work in your favor. So again, I've had to do this where we had to go and get all the bank records. We had to go and get medical records. We had to go and get police records.
Oh,
believe it or not. We had a situation, as I was saying, there was a case where we were trying to get a guardian removed. The guardian had actually been convicted of assault and battery on the protected person.
Oh,
and that happened before all of these reforms came in. And we brought this to the court's attention, said, look, here it is. This person has actually physically abused this person and has been convicted of doing so. And oh, by the way, is in violation of the terms of his parole as well. That is the type of thing that we presented to say this person is not a fit guardian.
Wow.
So yeah, I mean, this is where it starts looking a lot like litigation. Like I said, once upon a time, a lot more attorneys did this because it was, fill out the petition saying this person needs a guardian, and the judge would say, okay, rubber stamp it. Yeah,
Right.
Great, now you're someone's guardian. So, but not anymore, particularly if there's any objection, and that objection often comes from the person over whom they are seeking guardianship.
Well, now we're here in Vegas. So obviously there are a lot of people who, you hear them say this too. I have no family. I have no one. So can they still become victims of this guardianship fraud or, obviously because they don't have somebody they could designate as power of attorney or anyone like that.
Right. And frankly, I would say this, as I said before, those people are just as vulnerable, if not more vulnerable, to other bad actors out there. Like I said, I don't think it's particularly fair to paint all of the guardians with a black brush and say that they're all evil people and this whole system is fraudulent, because that's certainly not the case.
Right.
Unfortunately, that was the message that got sent, particularly through, some of the things in the media. But again, these safeguards are built in to the guardianship system. There is plenty of abuse going on out there outside of that, and people taking advantage of seniors. We had a case, we actually referred it out, but it came to us. An older gentleman with considerable assets, caretaker was taking advantage of it. She convinced him to sign a power of attorney, giving her the authority over him. She turned around and retitled all his properties as joint tenancy so that she would get them when he passed away. She hired an attorney who set up a foundation in his name where they were funneling money out. Oh. So what happened, a friend of his called me and I said, this isn't the type of thing I do, but I know an attorney who does. And without having to go through guardianship, they were able to do that. They were able to make the changes and, essentially get this person removed as the agent or power of attorney. And I don't know all of the actions that were taken in that, except I got an email from the person who called me telling me how happy that person was now that they had these bad influences out of their lives. So is it possible that someone could still be taken advantage of in guardianship? Absolutely. But that's why we have these systems in place. But again, yes, it can happen. I wish there were a little bit more oversight, because, if you filed there's follow-up. Once you become someone's guardian, you have to file an annual report. This is what the person's situation is, et cetera, et cetera. Here's the accounting if there's an estate above $10,000, and the court will look at that and say, well, if it looks good on paper, we'll let it go on. It may not necessarily be that way. So it's possible that this could happen. It's less likely to happen, quite frankly, in guardianship than it is outside of guardianship.
Okay. So, but now back then, going back to the old days of, what we've heard about prior to, was that a thing where people had to submit reports, annual reports, or were they not doing that back then?
Technically, yes, but there wasn't a lot of follow-up. And frankly, this was before my time. It's funny, when I got, like I said, I got to Nevada in 2017 when most of these new laws were being passed. And I actually spoke to an attorney saying, why are you getting into guardianship now? Well, because frankly, I'm tired of turning away work, but I never dealt with that before, where they saw this as, oh my God, there's this burden now. This is such a difficult process. I came from the world of civil litigation. Okay, so we file a petition when we present evidence if we have to. I can do this. So like I said, there were a number of changes that were made. Technically, they're supposed to be doing those reports. They don't always get done, and there's not always the rapid follow-up when they're not done. But the courts are looking for red flags. I wish the courts had a little bit more in the way of resources to follow up and keep closer tabs on what's going on. But if someone comes forward and says there's something going wrong with this guardian and the person they're supposed to be protecting, then they'll look into it. But I really wish they would be paying a little bit more attention as things go along.
Yeah. Well, what if a person dies? Are they still, at that point, are they still not the guardian, or what's, how's
that? If the protected person passes away, the guardianship ends. Now, the guardian still has some duties. There's going to be a final accounting, where they're going to ask, okay, so when, you became the guardian, the person had $300,000. Now this person has $120,000 and you were the one handling all of their money. Where did it go? So you have to have that accounting. You have to make sure your I's are dotted and your T's are crossed. These provisions that should be made. And again, it happens at the end of the game, but I would like to see it more in the beginning. I mean, there's things like you need court approval to make expenditures over $5,000, for example. So if you bought the person a car, you're really supposed to tell the court, look, we just spent $10,000 on a car for this person. And maybe it comes up at the end of the day and the court's like, okay, you bought him a car. You should have told us you didn't. Slap on the wrist, off you go. But yeah, the guardianship ends when the protected person passes away or no longer needs a guardian. And that happens too. We tend to see situations where, people have degenerative dementia and Alzheimer's where they're just not getting better. But there can be situations like, for example, if someone has a brain injury, it can be very, very serious at the beginning, but they can get better. And they could get to the point where they can live independently and make their own decisions with or without supports, at which point you come forward and say, look, let's terminate the guardianship. And that was part of the webinar I was listening to earlier today, how to terminate a guardianship.
That's interesting. So you can terminate them if somebody...
You absolutely can.
Wow.
And it can be done by a family member or the person under guardianship.
What if somebody doesn't report those changes? Like we're saying death, say if they're receiving Social Security and they still want to collect the Social Security. So they won't report the person is dead, or they won't report the person is, getting better or showing improvement. Has that happened as well?
So sure, and again, these are things that happen both inside and outside of guardianship. There are supposedly, a large number of people over the age of 110 still receiving, Social Security benefits, but it's actually someone else getting them.
Right.
And that is, of course, a different crime, taking advantage of people and, by the way, defrauding the government. But can it happen when these things don't get reported? Absolutely. And can there be consequences? Absolutely as well. If it's serious enough, and, if the court finds out, for example, that, someone allegedly took the person's money to start paying for caregivers and it was all a sham, well, that is fraud. And that is certainly the type of thing that will get someone, the court will say, look, you have shown you cannot be trusted as a guardian and we are going to remove you. But unfortunately, that usually takes someone else coming in and saying, hey, look, there's something going wrong. But if no one's reporting it, it's a much more difficult thing to do. The courts are supposed to do every 3 years a review. But again, as I've said, I think the problem is that if it looks good on paper, they're more likely just to go on through it. And I really wish there were a little bit more oversight.
Yeah. Well, I mean, I could see a family member, going, well, I'm collecting this person's Social Security money. I'm their guardian. Yeah. I use it to pay, like you said, pay for their health expenses or, their living expenses, sure, or whatever that may be, when really they don't report that the person has passed or whatever's going on with that person.
Right. And that's something, and frankly, really most people under guardianship it's a family member who's taking care of them. And again, both inside and outside of guardianship, we've seen this before, even with the power of attorney. Well, grandma wouldn't mind lending me $2,000 to fix my pickup truck. So, I'll just go ahead and take that money and go ahead and do that. And I'm sure I'll be paid someday. That's the type of thing that, again, is easy to get away with outside of guardianship because you're not going to have that accounting at the end of the year.
Right. Nobody's looking into that. It's a relatively small amount of money.
But and elder abuse, financial and otherwise, is a problem. It is a problem in all areas of society. It is not something unique to guardianship. And at least in guardianship, there is some oversight that you're not going to have outside of that. So if you choose someone to be your agent under power of attorney who turns out not to be as trustworthy as you thought, there could be problems. And again, people will call me and say, well, this is what's going on. That's not something I personally do. That's not part of elder law that I do, but I certainly have referrals for people who do. And they get good results.
So if you're like, say, my age, you're 47, you designate somebody as the power of attorney. And, right now that you're thinking, okay, that person's going to be like, for instance, let's say it's my brother, who's younger than me. So I'm thinking he'll probably outlive me. But let's say, God forbid, something happens to him. What can you change that then? The power of attorney and say, look, he just died.
You can certainly do that. You would want to. And that's the other thing. An agent can resign as well. Even if your brother just decided, I'm tired of dealing with Max. So, I'm not going to do this anymore. But what we tell people is put alternates in your original power of attorney, saying that, it's going to be my brother. If not my brother, then my sister. If not my sister, then my son. So there's always someone in place, because we've had situations where, give you an example. A woman came to us because her husband was in a nursing home, was trying to get the government to pay for that. And she had the power of attorney for her husband. And I'm looking at that and I'm looking at hers and says, you named each other's power of attorney? Yes. As agents under power of attorney? Yes. So your husband is currently your agent if anything should happen to you? Yes. This is your husband with dementia in the nursing home? Yes. You need to get a new power of attorney. You need to name someone else. So this is why we tell clients, you should follow up every couple of years. We'll reach out to them and say, hey, how's everything going? Any changes in your life? And frankly, there's always changes to the law too. So we will reach out to people and say, yeah, remember that trust we set up for you? The rules have changed a little bit. So we might want to revisit that.
So you do follow up on these. There's not an additional charge or anything like that. This is part of the package, basically.
Well, when someone retains me for services, I will get retained to do X, Y, or Z. Let's just say, for example, you hired me to do powers of attorney and a trust for you. And once I've delivered those documents to you, I would then send you a letter saying, great, we've done this. You're all set right now. And this is the end of my representation. I am no longer your attorney. However, if something should arise, please give me a call and we'll sign a new retainer essentially. But I will also reach out to people and just say, hey, look. And I know there are attorneys out there who do have annual subscription plans saying for a mere, I don't know, $500,000 a year. Yeah, I will continue to be your attorney and I will send you newsletters and, but that I shouldn't be picking on my colleagues like that, but it's what people may or may not be looking for. And depending on how complex your life is, that might be something you really want to do.
Well, the laws you're talking about, going back to the guardianship and all that type of stuff, is that just for Nevada? Because you had talked about the case earlier where a guy came from California who had a guardianship, and now they're trying to get the guardianship removed when they come here. So
right.
Are the laws, do they differ from state to state, or are they all pretty
They differ from state to state. There is no federal guardianship law. It is, each state handles things a little different. There are uniform guardianship codes that the legislature can adopt in whole or in part or with, little twists and turns. Frankly, Nevada has become a model with the legislature that we have the legislation that we have enacted to protect people. So, but again, it's really a lot about the execution as well. So, and when a person who is under guardianship leaves the state, what will typically happen is you will get an order from that court saying that we are going to terminate this guardianship upon getting an order from the court in the new state. For example, leaving California and going to Nevada. Once we get that order in Nevada saying, okay, we are approving a guardianship here, then the California guardianship terminates. And then we are within the Nevada system where we're going to say, look, we don't think we need a guardianship. We think there are less restrictive alternatives available that we may still ask for some level of judicial overview, but full-blown guardianship probably not necessary. And different states have different views as to what is necessary. Least restrictive alternatives is something you will hear a lot. It's just a question of, what people will view as what is necessary, not necessarily what is least restrictive. And unfortunately, there's a lot of court systems and attorneys like, it's just simpler. Let's just make them guardian of everything.
So some states, but I guess some states still have those archaic models like we used to have. Is that still, because I'm sure it's going on in other states now, huh?
Sure. And I certainly can't speak to all the states and what they're doing. I'm licensed here. I'm licensed in California. I do not do guardianship or conservatorship in California. But they've had revision, changes in the law as well, in part because of the backlash to the whole Britney Spears thing. But there are legal aid organizations across the country and in every state who are lobbying for these types of changes to make sure that people have the utmost autonomy, have the utmost freedom. By the way, one of the things that came out of the changes in 2017, the legislature actually passed a Protected Persons Bill of Rights, and there are 19 specific rights that someone under guardianship has. And if the guardian is depriving the person of those rights, some of them are very basic. The right to be treated with dignity and respect, the right to have visitors of their choosing, the right to not have their communications interfered with, things like that. Those are things that can be brought to a judge as well and saying, look, this person's rights are being violated. I've had to threaten to do that. Situation, like I said, with a visitation, where one family member says, well, no, I really don't want this other family member to know where this person is. Like, well, that's not your decision to make. And if you make that decision, you need court approval. Well, that person is, no, don't tell me, go tell the judge. Otherwise, you let this person know so that they can go visit their family member.
What about the dignity?
This is why advocacy is such a big part of my job.
Yeah, I guess so. Well, what about the dignity and respect thing? I mean, obviously that's kind of a hard thing to prove, right? I mean, how would you be able to say, hey, wait, this guardian's not, letting this person bathe or something, whatever the case may be?
Well, actually the case I was talking about where we removed the guardian was being physically, not just physically abusive, but mentally and emotionally abusive as well. And we brought this up, and it was in front of family members who saw this. And it's like, you're just not treating this person right. Insulting them and putting them down and, manipulating them. That's not treating someone with dignity and respect.
Right,
and we put that in front of the court and said, look, their rights are being violated. This particular one, it was fairly easy to get the guardian removed because there were so many things that went wrong, including, as I said, the conviction for assault and battery, things that should have resulted in him not being a guardian long before that. But when the time came, we presented the evidence. We had the witnesses take the stand, and what did you see? And here it is. And then in closing arguments, I told the judge, they have the right. The protected person has the right to be treated with dignity and respect. And what we have seen here, this is not dignity. This is not respect. And the guardian should be approved. And we were successful.
That's awesome. That's great. Well, I'm glad to hear that there's things been put in place. Because like I said, when I was first presented with that whole story, I was like, oh my God, this is scary.
It is. And this is something I really want to, bring it home, because this is such an important topic and it's so very misunderstood. And there's so many misconceptions out there because people have seen things like The Guardians, which was a documentary based upon what happened in Nevada. It came out in 2018 after these reforms had been made, but it didn't talk about those reforms. And it gave the perception that things hadn't changed. They talked a little bit about some of the changes, but really they left the impression that this is still going on. And that was not a fair depiction. And then you have things like I Care a Lot, which came out in 2020, and I cannot emphasize this enough, is a work of fiction. It is loosely based on actual events, but I can guarantee you the Russian mafia has not infiltrated the guardianship system in the state of Nevada. And this is why I want to get out and educate people, because people believe that this is the way things are and that nothing has changed. And when people are afraid to get the help they need, they don't get it. And that leaves them more vulnerable. Yeah. So if people know that, that there are safeguards in place, people can even ask to have a guardian appointed for themselves, but I don't want people fearing guardianship. I want people to understand it. I want their rights to be respected within the system. But if it's just an irrational fear based upon, what people have seen in the media, you're doing them a disservice.
Yeah. Well, like I said,
unfortunately, if you're trying to sell the rights to a movie, if you're trying to sell subscriptions to magazines, the lurid and horrible tales or what sell. Well, and what I'm telling you now is not that exciting.
And fear too. Fear is a good way, because obviously people are going, oh my God, I got to see this, let's check this out. I can't believe this is going on, because this was first presented to me last year in 2022. Mm-hmm. That's when we had this person on. And then obviously at one of these networking meetings, you got up and you said things have been changed since then. And I'm going, oh, wait a minute. So we never want to present only half the truth. And that's why I said, well, we got to get Patrick on here, man, to just, sort of enlighten people a little bit, because obviously that's not how it still is.
Correct. And the system's still not perfect. There's still room for improvement. Like I said, I'd like to see a little bit more closer oversight on what's going on. I'd like to see the Guardianship Commission reaching out to all of the players, the people, the guardians, more the attorneys who are practicing in the area, take a look at, do a review of these reforms and say, how are they working? And hear from everyone involved so that we can continue to make improvements, because ultimately the goal is to protect people.
Right.
Give them the protection that they need while giving them as much autonomy as possible.
Right. Wow. Well, Patrick, I appreciate you spending time with us, coming on. Do you have any contact info you want people to know, like a website or, whatever?
Certainly.
For people to get in touch with you?
Sure. Have the website. It's www.cliffordseniorlaw.com, and it's spelled out just like it looks on the screen, CliffordSeniorlaw.com, or email at office@CliffordSeniorLaw, or you can call our number, which is not the same that's on the website anymore, 702-856 I'm sorry, 702-956-8048.
I hear Kathy sort of coaching back there.
You hear Kathy keeping me honest here.
That's what she does, man. So, well, hey, again, Patrick, thank you for spending time with us. Hold on with us when I end this, or after I end this real quick, just so we can say goodbye and all that fun stuff. But anyway, this has been the Nothing Sacred interview with Patrick Clifford of Clifford Senior Law. I'm Maxwell Silverhammer, and that's the story there, bitches. See ya.
We are nothing sacred. We are nothing sacred. We are nothing sacred.
With Maxwell Silverhammer.
We are nothing sacred. With cruise control. We are nothing sacred.